Morning, everyone. We'll get started here in a few moments. Just waiting for the last few people to join. All right. All right. I think we can go ahead and get started. Good morning, everyone. I'm Bella. Today we have Nick Blessing with us. He's going to be talking about eviction expungement. Nick, take it away if you're ready.
Thanks, Bella. Thanks everybody for joining us this morning. This presentation that I'm giving today was made by our Director of Advocacy and Litigation, Casey Johnson. So thanks to him for creating slides for this. This is a pretty exciting new development that we have this last legislative session. Substitute for House Bill 2357 was passed by the legislature and went into effect just on July 1st. So this provides a brand new procedure for evictions to be expunged through the district court. This is it's going to be pretty interesting. There's a lot of there's a lot of people that are really interested in getting involved in this and trying to utilize this procedure as best we can. This is a procedure which the primary intent here obviously is just to eliminate that public record, which is like a scarlet letter to many people who have had housing issues in the past and have issues primarily with finding housing in the future, because prospective landlords obviously can look at these court records. They are public record, and they can find these old eviction cases. And even for cases that were dismissed, either voluntarily or say they even went to trial and the tenant won at trial, a lot of landlords don't even like seeing that that eviction case is there, that it was even filed. And I think a lot of times they don't look very closely at what actually happened in that case. Like I said, this just went into effect on July 1st. And really important here, and this is something that could be a future topic for amendments to this law that just went into effect. It's not a perfect bill. Few of the bills that get passed are. The new bill actually specifies that this only applies to evictions under the Kansas Residential Landlord and Tenant Act. And I'll get a little bit more into that in a bit, but the really important thing for us to understand is what's the criteria for someone to be able to actually expunge their eviction case. And the big thing is there's 3 years has to pass since the final judgment in the case was entered. There's a little bit of an odd wrinkle to this. There's an odd way that the bill was written, is that now there can't be a subsequent eviction within those 3 years in order for that eviction to be expunged. This is really similar to expungements for criminal cases. But the thing that's kind of funny about this, and it took me a second, and I remember I was talking to Casey about this, and it took me a second to understand how this actually works, is, say for instance, somebody had an eviction 10 years ago and they want to get it expunged. But if they had an eviction case 2 years after that, they can't expunge that eviction. They actually have to expunge the subsequent eviction before they can expunge that one. So a little bit of a problem with the law is if somebody goes almost 3 years, not quite 3 years after an eviction case, and they want to get it expunged, but just within that 3-year timeline, there's another eviction filed. Well, now they've got to wait another 3 years after that subsequent eviction. So that's a piece of the way that this was written that I don't like so much. But that's what the law is, and that's what we need to understand in order to advocate for people and help people understand what they'll be able to do. The other piece here is that the debt has to be satisfied. The defendant does have an obligation to show that they don't owe any money. However, there is something else in here that I'll get into for a second, which is kind of nice here. It is set up for electronic filing. There is an electronic filing system for pro se tenants to file. I've taken a quick look at that. I think that's been passed around. If you haven't seen that, or if you're interested in seeing that, reach out to me or Casey Johnson, and I think we can find it. I'm sure I just have to dig through my emails and I'd be able to find it. I know the link was emailed to me. But one other thing that's really great about this is the filing. There's no filing fee. It's no cost, which that is different from a criminal expungement. Criminal expungements, you have to pay $195 unless you can get it waived. But here, you don't even have to file a poverty affidavit and an order waiving fees in order. Um, yeah, I'm going to put my email in the chat. So that's something that's kind of nice about this. So just so you know. That's my email right there. I'm also just in case anyone is interested or you haven't seen it, I'm going to put in the chat here also a link to the bill itself. Okay. So the other part of how this works is the landlord or the plaintiff in the eviction case does have an opportunity to object to the expungement. They get 30 days after they have the petition for expungement served to them. But if there is no objection filed, a satisfaction of the monetary judgment in order to allow the expungement to go forward is presumed. So that's also pretty nice. So there's probably, and one thing that's kind of funny about this, which I'm going to also circle back to this idea. There's a lot of really old eviction cases out there. A lot of really, 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 really old ones. You know, could be, 10, 20 years, maybe longer that are still available on the public record. Um, a lot of those landlords might, as a corporation or a corporate entity or as a individual person, may not exist anymore. They may be they may have been dissolved, or if it was a person who was the landlord, they may have passed away. Um, but the bill does specify that just the fact that an eviction gets expunged, that in itself doesn't mean that the monetary obligation is extinguished or is satisfied. But they have to, but so there's kind of this weird, like they have to show that it's satisfied, or it will be presumed that it's satisfied. But it's possible that someone could get an eviction expunged, but they actually do owe money. So it's that's kind of funny, but that's what's in the bill. Now I do want to bring up here sections 2 and 3 of the bill. Section 1 of the bill is what has all the eviction expungement pieces in it. Sections 2 and 3 actually are amendments to certain parts of the Code of Civil Procedure for evictions in limited actions court, which now require that judges have to consider mediation in every case. And if they order mediation, the courts have to continue the case for up to 14 additional days. So the possible consequence of this is, and one thing I talk about a lot in other presentations that I give, is that eviction cases are very fast in Kansas. Kansas is one of the fastest states in the country for an eviction to be completed through the courts. This is a way that it could be a little bit longer in some cases. Haven't seen yet how any courts have dealt with this. Obviously, this just went into effect 1 week ago. So we'll see how that gets adopted. Obviously, in Johnson County, we already have a mediation program. I'm not sure if this is going to change the way that Johnson County operates their mediation program. But a nice benefit of this is this could also encourage there to be more settlements in eviction cases and have fewer of them result in a judgment. However, the the court can't order mediation if they find that mediation would be unhelpful or impractical. So there are forms. Back to the expungement part. There are forms available for the eviction expungement already on the Kansas Judicial Council website. The main thing is obviously just the motion for expungement, which has to be filed in the actual eviction case. And basically, the whole idea is it's going to state that 3 years have passed and there hasn't been any other eviction within that period. And there has to be some kind of statement or attachment that shows that the debt was satisfied. And I think there's some interesting questions about this, because one thing I thought of while I was looking over these slides is many of the judgments that probably a lot of tenants are going to be trying to get expunged are ones that may be dormant and have been dormant for more than 2 years. And if that's the case, if that's the case, then there really is no debt anymore. So I'm kind of wondering how that might be dealt with, or if that would be a good basis to say that the debt is satisfied. I think it should be. Now, and another important part of this, as I was saying before, the landlord has to be served one way or another in order for the expungement to go through. So under KSA 6303, the way to do service of process by certified mail with a return receipt delivery is the way that we are to do this. So certified mail with a return receipt. They're going to have to file the green card, the return receipt itself, in the case to show service. And then the date that the landlord was actually served, that's the deadline that starts the landlord's 30 days to file an objection. And that receipt should be attached to a return of service that's signed by the defendant or their attorney. Katie?
Did you want us to wait till after for press questions, or do you care?
I don't care. Do you care, Bella? No, go ahead.
Got
Okay.
time, go for it.
I think I answered this myself, but I want to make sure I'm reading it right. Section 4 says if tenant has an additional judgment entered in an eviction action, the preceding judgment shall not be expunged. So this doesn't include if they get another action filed against them and they have a dismissal, for example. Because that's
Right.
technically a judgment, right?
Wait, you're looking at the bill?
Yeah.
Yeah, subparagraph
4.
A4.
Yeah.
Yeah, if the tenant has an additional judgment entered in an eviction action in which the underlying rental agreement.
So I'm presuming
You know what? That's a good point. That's a good point. See, and this
But
is the fun thing about this is this is brand new, and
I feel like we'll get some landlord attorneys who are, there was a judgment.
well,
Thank you.
so there's a funny thing about this too, because I think my answer is I don't know, Katie, because the other thing about this is this bill, it doesn't talk about expunging a, God, I should look at the bill, because if I remember right, it doesn't talk about expunging a case where it's been dismissed. So I think sorry.
I'm saying yes, I agree with you. That's my part. That's my.
So I think we want to, so there's kind of a double-edged sword here, because I think we want to also expunge dismissed cases. So we would like judgment to mean a final judgment, which would include a dismissal.
But then that precludes people who maybe we've helped get a dismissal, but they haven't had one. Other than that, they haven't had an eviction in 3 years. So then if we're interpreting that dismissal as a final judgment, then they can't petition because it's been
Well, they have to wait till 3 years after the dismissal.
exactly.
I think they have to wait 3 years after the dismissal, regardless. The way that this is written. Let's see here.
I feel like there's some, it's not, I mean, I don't think it's clear, but maybe I'm just dumb and
I mean,
silly.
we're probably going to spend a lot of time looking at this bill and analyzing it. And I know a lot of people have already done that. I know Casey certainly has. He's definitely looked at it more than I have. But from what I recall, we still have to wait years even if the eviction case was dismissed.
Okay.
Um,
That was
to answer Dennis's question, I am actually going to get to that in just a minute, because if Dennis, if you're asking specifically about service of process, let's see here. So for sure, if the business entity cannot be found, there can be service on the Secretary of State. And the essential case here is if the corporation or LLC is defunct or dissolved, then service has to be had on the Secretary of State, which I've never had to do that before. I've looked into it before, but yeah, the one thing that kind of stinks about that is there's a $40 fee in order to do that. So
Nick,
that is what would have to happen. Yeah, Matt.
I have to jump off to get another call, but I wanted to say to this assembled audience that obviously cares deeply about housing issues, we need to look for client stories that have been impacted by this law change. We need to bring visibility to this bold act by the legislature and identify how families are benefited by this. Because this, I don't know exactly how this law change came about, but we need to give props to the lawmakers so that they realize these kinds of changes do impact lives favorably. And we have to find those stories. We have to find those stories because, in my experience, a lot of the people, just the average Joe in the street, doesn't give a shit about housing. And so this is a bold step. A lot of lawmakers probably don't have any appreciation for how impactful this is, and we have to inform them and give them kudos for that. So everybody on this call, if you have clients, families that are able to take advantage of this law, we've got to capture those stories. We have to personalize it. And then, like Nick said, we can trim the edges of this bill and make it more friendly to these parties that are taking advantage of it. So they say democracy dies in the dark. Well, civil justice dies in the dark. And we have to shine the light on these families that are going to be benefited by this law. That's it. That's the most important thing. We did this with the driver's license suspension initiative. We told client stories about people who missed a court date. It put context into this horribly unfair law, and the lawmakers saw that. They understood that. And they have since made a number of changes to that law to give judges the power to waive fines and fees. And so, actually, lawmakers, if they understand how certain laws unfairly impact working men and women, they can be persuaded to change how things function. And this is a good example of that. So I got to drop off this, but everybody here, try to find the stories because let's face it, the TV stations and the newspapers are desperate for feel-good stories. They're desperate for cases of hope and transformation and second chances. This is really about second chances. So that's all I'm going to say. And I'm going to drop off. But everybody collectively, we all need to work together to find these stories and share them. Thank you.
Thanks, Matt.
Nick,
Yes.
going back to the return of service green
Mhm.
cards,
Yeah.
how specific are they going to be with the date signed by the party?
That's a
Because
really
I
good
work with
question.
certifieds all the
Yeah.
time, and the postage people don't get the date signed.
I know. And we've talked about that before. Yeah. And Kathy's a paralegal in our office, so she helps us with that kind of stuff a lot. I know Kathy actually puts you like highlight. You use a highlighter and you put a highlight on
I
the place
do,
where they need
and
to
it
put the
still
date.
doesn't work.
It still doesn't work. Well, isn't there? Well, usually there's like a tracking thing too, right?
There is.
So you can look it up online, and so you should be able to get the date from that. But the return receipt, they're supposed to sign it. I mean, hopefully. I mean, have we had a lot of cases where someone objected to a problem with the return receipt? I've never heard of that happening. I don't think people
when I
really.
filed the certification with the court, nobody's ever said anything.
Right, or like
I
an opposing
generally
party
use
objecting to it or something
no,
like
I
that.
generally use the date we received it because we'll have our date stamp on it.
Well, that's so if you want to play it safe, that is something that people could go by to allowing more time in case there is some kind of ambiguity. So I think that's a good point. Thanks, Kathy.
No problem.
Let me see here. Tanya Kendall. I do not see a limit or restriction on the number of eviction expungements a client can obtain. Thus, if a party had an eviction 5 years ago and a second one 3 years ago, may the client file for expungement on both evictions simultaneously? Yes, I think you can, and that's actually how I took a look at the motion for expungement form, and it actually does have like a checkbox that says something like there was a subsequent one, but that one is now also eligible for expungement. So I don't think that that's going to be an issue. I think that people should be able to do both of those at the same time. And the statute actually says, hold on, court shall grant. Let's see. Yeah, so it actually says section A4 that Katie and I were talking about. It says that if the tenant has an additional judgment entered in an eviction action in which the underlying rental agreement is governed by KSA 582540 within the 3-year period, the preceding judgment shall not be expunged until the ensuing judgment is eligible for expungement. So once the second one is eligible, then the previous one and the second one can both be expunged. Let's see. I'm just making sure there's. Let's see, Everett. Yeah, so here I'm just gonna put it in again because the amendments to the Code of Civil Procedure for Limited Actions are in sections 2 and 3 of the bill. And this is the bill right here that I just put in the chat. So those are the amendments. The statutes that are changed are KSA 613807 and KSA 613806. Okay. Let me see here. So, and I also saw another comment that apparently the Social Security fee is $50, not $40, which I didn't know that, but that doesn't surprise me. M. Sapinoff, you got your hand raised?
Yeah, hey, it's Mary Sapinoff from Johnson
Oh,
County
hey,
Housing.
Mary. Hey,
Yeah,
Mary.
hi, sorry. I was the one about the 50. I on the website and talked to Mark from Secretary of State who does the services like department. He said it was 50. Casey said there's a potential because the statute says 40. I just want to give a heads up because I don't know which way we want to go about of advertising if it's 40 or 50.
Okay. Okay. I'm not sure. We'll have to figure that out. Thanks.
Okay.
Thanks though, Mary.
Yeah.
Um, so I'm just moving on here. Another form that I believe one has been created. The plaintiff can file the objection. The main basis for an objection is that there is an unsatisfied debt. There was another eviction within 3 years after the judgment that's the tenant is seeking to expunge, or they could challenge service of process. Those would be the main objections that we would possibly see. So that, and this is all the same stuff that we're basically talking about here. So obviously, once an order of expungement is filed, that would seal the record from public view. Now, real quick, there's a couple of insights here. Some, like we said, can old evictions be expunged? Yes. We talked about how if the landlord has died or the company has been dissolved, now if the landlord was a person and they've died, then their estate would need to be served. And I'm not sure how that's going to be done. So that's something else that we may need to figure out, or maybe other attorneys on this call have ideas on how that can be done. Effect on credit scores. The public record, once it's removed, that should stop it from showing up on any screening reports. Although I'm not sure if, a landlord could still be claiming the debt and that could still be reported to the credit reporting agency. So I would expect that there'd be a significant delay in this affecting credit scores to the benefit. And now the scope of this, we have this question here, commercial evictions, obviously does not apply to commercial evictions. It specifically applies to residential landlord and tenant agreements. But there's one little problem that I see is that if the tenant was evicted and they have a mobile home, that's not, and they own the mobile home and they were renting a lot space, that's not covered by the Kansas Residential Landlord and Tenant Act. That's covered by the Mobile Home Act, which is a different set of statutes, which I'm not sure if the intent was to include this, because what it says here is that the underlying agreement has to be governed by KSA 582540 et sec. And I don't think that includes the Mobile Home Act. So that might be a little bit of a problem. And possibly a reason why this law might need to be amended in a future legislative session. I don't know if maybe somebody else has another opinion about that maybe it actually does include that, but as far as I can tell, it does not. So big thing to be thinking about how can we leverage this new law? And I think what I assume we're thinking about doing is doing expungement clinics, which Kansas Legal Services has done many expungement clinics for criminal expungements, and now we can potentially do the same for eviction expungements. And I think these will probably be easier than the criminal expungements. Um, and explaining the law and following up after we attempt to do these and see if it's actually been removed from the public record. That is our slides on this presentation. I see a question from Joy. What if you have 2 or 3 evictions? There's no limit on how many you can get expunged. The only thing that is just that there has to be 3 years after the eviction before you can apply for the expungement. Yeah, 3 years have to pass, and there can't be another eviction case filed during that time. And any other questions? I think we've got plenty of time for more questions. There's a lot in here that I think we're not 100% sure about yet. I'd also entertain any other thoughts or observations that maybe I haven't addressed.
I know
Nick, it seems to,
Bella. I'm sorry, Dennis. I think Bella has the documents that I sent to her.
Bella, what
Yeah.
what documents, Joy?
From the Judicial Council, just the forms, how to fill it out, and the link to the website to file.
Yeah, do we have that link? We could just put it in the chat.
yeah, we'll add it to the chat. I'm looking for it right now.
Okay, thanks. Let's see, I saw a couple. Yeah, so what if the second eviction is 4 years after the first eviction? Yeah, so this is the funny thing about the law. If it's 4 years after, you can expunge the first one. If 3 years passed and there was no eviction in that time frame, the eviction that preceded those 3 years, that can be expunged. The even if they're, I mean, I think, unless I don't know, maybe unless I need to look at this bill more closely, even if they're being evicted right now, they can expunge a previous eviction if 3 years have passed. Yeah, because the only thing it addresses is on. Hold on a second. This is the bill right here. See this? Section 4 here. This is the only thing that addresses a subsequent eviction. It has to be within the 3-year period in order to stop the expungement. Yeah, and so Anna's question, for example, if there are 2 evictions that are 10 and 8 years old, those are both eligible. As long as the debt has been satisfied or the landlord agrees to the expungement, or if the landlord is served and the landlord does not file an objection. But the funny thing about a case that's 10 or 8 years old is those eviction judgments could be dormant. And if they've been dormant for 2 years, then the eviction, the order, the judgment has to be released. And if necessary, what a tenant could do even before um, filing the expungement is they could file a request with the court for the judgment to be released, meaning that there is no debt anymore. If you have a debt for $10,000, but they never tried to collect on it for 7 years, it can be released by the court, and then there is no debt. Um, let's see here. Carolyn's question for out-of-state evictions. How would someone find out what that state does? Well, you'd have to look at that state's laws. And as far as I'm aware, there's not very many states that have a procedure like this. I thought when we went to the governor's signing of the bill, I thought I heard someone say that we're like the third state that has this. I don't know if that's right. I don't know if anybody has an answer to that. But there's not very many other states that have this procedure. So
Would
most
that
likely, yeah.
would that impact their ability to get it expunged in Kansas if they have one sitting out here someplace for a different state?
No,
Okay.
absolutely not, because this right here, this section right here, what does it say? It says if tenant has an additional judgment entered in an eviction action in which the underlying rental agreement is governed by KSA 582540 et sec. That means it's a Kansas case. A rental agreement in Missouri, guess what? It's not governed by Kansas law. So it has no application to this. This is completely, as far as I understand, I'm pretty sure I'm right. This is completely self-contained in Kansas. Okay, thanks for putting those forms in. Raya's put the forms in the chat here.
Yeah, I'm
And
also adding if you have any issues accessing it, I'll put Bella and I's email just so you can we can troubleshoot and get it directly to you.
thank you.
It seems to me like the biggest impediment to many of our clients taking advantage of this is the requirement that all of the past expenses and judgment and everything be paid.
Mm-hmm.
Because usually the time when you're being evicted is because you can't pay. And that, I mean, I understand why that has to be in there, but it just seems to me that may limit the availability
Oh,
of
yeah.
many of our clients.
I think you're right. There are a lot of evictions though where and it depends a lot on what county you're in and the practices of the landlord attorneys that are doing a lot of the evictions. But there's a lot of cases where they don't do a judgment for any money. They just do possession. So if the case is literally just for possession, then there's no monetary judgment to worry about. Um, Sometimes it's only the court costs, which should be like $76 or something like that. But
Yeah.
actually, yeah, I think that's right, 76. So yeah, Dennis, you're right. It's that could be a real barrier for a lot of people. I'm sure, I mean, maybe with other different organizations kind of looking at this, I mean, maybe there will be rental assistance provided for some people so they'll be able to get it taken care of. I'm not sure. I haven't talked to anybody about how we might address that. But yeah, it's definitely a good point. But if it's old, like I've been talking about, if it's a really old judgment and if it's been dormant for 2 years, it can be released. And then I think there's a good argument that that requirement isn't really necessary because the proof
Right.
is this court released this judgment. Right? Brandy, says, I spoke with my local district court clerks, and as you can imagine, are overwhelmed and with little to no training on this bill. Will KLS or the OJA provide training for the courts? The court had one person apply so far and has ran into questions they say OJA cannot answer. Well, yeah, I think probably I haven't thought about that even yet. I think I don't know that there's any thoughts about training clerks. They probably should get training on this, definitely, but you know what solves a lot of times what solves these kind of issues is there being an attorney involved. If there's an attorney representing the defendant, they can probably get past issues with the clerks not really knowing what's going on. Maybe this will be an opportunity for private attorneys to get involved pro bono, just because of the nature of this. I mean, it's not the same thing as defending against an eviction action and asserting counterclaims, which are, I tell you what, it's a lot more stressful and intensive than what this process is going to be. Carolyn?
Yeah, so McPherson Housing Coalition is hosting an expungement clinic in September. And is this something that attorneys could when people are wanting to be included in that clinic, is this something that they can get advice on?
Yes, Carolyn, we're happy to do that.
Woohoo! Okay, thank you.
Thanks, Joy. Let's see here. Just making sure. Oh, did I get? Hold on.
Yeah, it looks like
Okay. Sorry, there's a lot of comments.
yeah. It looked like the next question was pertaining to DV, domestic violence.
Whose question was that?
This is Anna Weens. Another question, if there are multiple tenants on the lease, do they have to file jointly for expungement, or can they file individually? Asking for domestic violence survivors who may want to pursue expungement, but contact with abuser is not safe.
That is such a good question.
Mhm.
This is why, like, all the people who are involved, whether you're with KLS or you're with other organizations, and you help folks with these kind of issues, that's a great question. Well, let's see here. I always just look at what the law says. So a defendant in an eviction action may make an electronic filing for an expungement at no cost. I think this means, in just the very first part of the bill, I don't think that it needs to be jointly filed. I think one defendant can do it. I don't think, and if it's sealed for one, it's sealed for everybody. I would assume. I think that's how the court sealing works. So and this is a great question, and this is my first time even thinking about it, but I
Hey,
think,
Nick.
yeah,
Sorry, this
yeah.
is Mary again. I was messing around with the portal form a little bit, and you can only select an individual. It won't even give you the option when you submit to select multiple people at a time. If that also helps answer your question. It seems like the portal and like the form on, like you have to select an individual to go through the full process.
Select an individual.
Yeah, like on the actual portal form. It won't let you select like the full household that all received the expungement. And I was talking to Jill Bourne from the courts, and it seems like she was also saying that it has to be an individual.
Well, okay, so as a practical matter, the way it's set up, it's going to be an individual and it's not going to be jointly, but it appears to me that it has to just be only one person has to do it. And that's probably why it's set up that way then.
I have a follow-up question for that because I'm the
Mhm.
CES liaison here. For those that are like in no contact for survivors, that wouldn't like alert the abuser if they do pursue the expungement, right?
I don't think so.
Okay.
I could be wrong though, because like I just said, this is my first time even thinking
Right.
about this.
Right.
But let's see.
Yeah, I'm just thinking, I mean, and
Because well,
typically most
here's the reason why. Here, just hold on.
Mhm.
Here's the reason why I say that. Because you're only required to serve the plaintiff. You're not, it appears that you are not required to serve co-defendants.
Mm, okay.
And unless the abuser, which I mean, it's not impossible, but unless the abuser were an attorney who's actually filed on the case, they wouldn't
Right.
get an electronic notification of the case being filed. I guess it's possible, depending on how the district court deals with it, that the district court might, because some district courts, what they do is, for different kinds of cases, they do uh, prepare a notice of hearing and they'll mail it out
Right.
to people. So it's possible that it could happen that way.
Okay.
Is the only way I can think of. However, even if that were the case, in many of these cases, especially if it's a case where people who are none of the people who are defendants in that case live at that property anymore, which in most cases that we're dealing with, they don't,
Hmm.
especially if they were actually evicted. Court doesn't have another address for the other defendant. I guess there could be mail forwarding, but is there going to be mail forwarding after 3 years? So I don't know. These are really good
Yeah,
questions.
for sure.
And so I think possibly if that there might be some danger of that, then the court is going to need to be notified and asked to
Yeah.
not do that. However, a lot of the courts that I practice in, they don't prepare notices of hearings for, at least not on eviction cases.
Okay.
Um,
Yeah, and some survivors will have advocates that are court advocates and can assist them. I know that some programs also offer confidential addresses. So it seems like
yes,
it would just be like kind of safety planning around going about this.
yes, that's a really good question to bring up, and that kind of safety planning may need to be really needs to be thought about in some of these cases if
Absolutely.
if there's an abuser who's a co-defendant.
Absolutely.
Oh, and thanks Christy for providing this link. I'm actually gonna look at this later. Sorry, I want to save that link because I want to look at that.
It looks like we got a couple more questions.
Yeah.
I don't know. Did we get to Tanya Kindle's about the limit restriction?
I do not see a limit or wait, I thought I had did this one. I do
Okay.
not see a limit or restriction on the number.
You answered.
Oh,
Got it.
okay.
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 Awesome. Trying to go down the list.
Uh,
It looks like the next one will be from Brie Kirkhart.
okay. This five are bifurcated based on being a protected person. Man. You guys have all these good questions. And I'm stumped. I would be bifurcated in an eviction case. Has anybody seen that happen in Kansas courts before? I'm on it. I legitimately want to know.
We've had it where the eviction process was started when we were in the middle of helping a survivor go through bifurcating their lease, and it was a corporate management company, and I went back and forth with them a lot. We had a staff attorney at the time that did, and they still moved forward with her eviction, even with us showing them the statute of being a protected person and their responsibility of and all of that. And they ended up dismissing it, but it's still on her record because they took the whole household for the eviction because they said the proceedings were already in process.
But they dismissed it, so there's not a judgment on that case, or there's not a money judgment on that case, right?
Right. But I didn't know if that was a possible thing that would happen.
Hold on a second.
I could just be creating a problem where there's not one. That's possible.
Maybe. Well, who were the defendants in the eviction case?
The survivor and the abuser were living together, and she had moved out, and we had filed all the protected persons paperwork, but they had already put her on the eviction proceedings and moved forward with court.
They put her on the eviction proceeding, but so then the whole case was dismissed? Or was she dismissed as a defendant?
I believe she was dismissed as a defendant.
And they proceeded with an eviction and got a judgment against the abuser.
Yes.
Oh, well, that sounds like a pickle. Because that is a situation that this bill was definitely not drafted to address. So I think that sounds like a problem to me, because if she was named as a defendant, but then she was removed as a defendant, but then there was judgment against the other defendants, and that judgment has not been satisfied. Correct. Is that right?
Yes.
That doesn't sound good. That sounds very bad. And that sounds like that might be a problem. Maybe there's a way around it. Yeah. How long ago was it?
It was 2023, I believe. So she's coming up on that 3 years if she hasn't passed it already, and she has not had an eviction since.
Good. I mean, the one thing that's really great about this is there's no filing fee for an eviction expungement. So there's no there'd be no, like, because the thing with the criminal expungements that we try to avoid when we do those is if you pay a filing fee, but there's some error with their criteria for expungement, and it gets denied, well, you lost that filing fee. But here there's no filing fee to lose, so she could try, and if they don't object to it, then it gets sealed. They're also, I don't know, that's a really interesting problem. So I don't know, maybe we should follow up about that one.
Thank you.
Yeah, no problem.
I started
Sorry,
second guessing. No, you're fine. I
good
started second guessing
curveball.
myself on like maybe I'm not even making sense or I'm going down a rabbit hole I shouldn't, but thank you
No,
for
I think you're right. I think you're right. I think there's a legitimate concern there. Um, okay, okay, any other questions? Oh, okay. Well, I guess that's all I've got for you. Thank you all for coming. This is and actually I'm really surprised actually because I think I think that there's a lot more that we need to dig into this. I think we've got some unanswered questions, and I think we're going to see how some of this might get addressed. And I'm optimistic. I like to think that, geez, you know, you got an old eviction case, and there's maybe some little problem with it. Are they really going to care? Are they really going to care? I hope not. Maybe some of them will. Thank you, Kelly, and thanks to Casey because Casey's the one who made the slides. And thanks to everybody else who's been working on this and everybody who advocated for this to be passed. It is a really good step in the right direction, and I think it's a real opportunity for a real benefit to a lot of our clients. Okay, well, I guess that's it. Anything else, Raya, Bella?
Yeah, thank you, Nick, for presenting. That was awesome, and very informative. We will get the recording and link to some of the documents out as soon as possible. You can find it on our website, but it'll also be on our YouTube as well. So look out for that. I'm going to put it in the chat as well. Um, yeah, if there's any more questions, feel free to reach out. Nick put his email in the chat earlier. You can always reach out to Bella or I for further information as well. Um, so yes, thank you so much.
Thank you all. Have a good day.
Thank you.